very broadly, what is intellectual property and what do patent attorneys in particular actually do. We'll then talk more about kind of the qualities that you might need to be a patent attorney, so you can start to think if it's maybe a career that you'd like to pursue. I'll talk about the training and the exams that you need to do to qualify, some of the pros and cons that there are for the job, in my opinion. And then if I haven't put you off by that point, I'll give you some application tips from my point of view that I think could help you in the application process. And finally, I'll finish talking about Mewburn Ellis, which is where I work. And then, as mentioned already, we'll have a question and answer session, but I might stop throughout to pick up any questions that have been given in the chat while we go. Okay, so a bit about me. I am a UK chartered patent attorney, so I'm qualified UK attorney. And I'm a part qualified European patent attorney, so I'm waiting on my results. I sat my European qualifying exams in March this year. I was meant to sit them last year, but they were postponed because of COVID. So yeah, waiting on my results of them. So I work for Mewburn Ellis. It's one of the largest and oldest IP firms in the UK. And I work in the engineering and ICT patent teams, so because I am a physics graduate. I live in London, I work in the London office, and yeah, I have a physics degree from Manchester University. So we'll now go on to what is intellectual property. So intellectual property itself is basically just an idea. And it can make you money, and you don't want people to copy your idea, so you want to be able to protect it so that you can kind of build a business from your idea. There's lots of different types of intellectual property, so we've got some listed here: copyright, trademarks, patents, registered design rights, unregistered design rights, and trade secrets. That's different ways in which you can protect your intellectual property. So something that not many people, or I didn't know before starting, is that some IP protection is created automatically. So, well, for example, trade secrets. So that's things like the KFC recipe or the Coca-Cola recipe. They just keep it a secret and therefore no one can copy it. Copyright. So that's if you write a book or you compose a piece of music, that's automatically protected by copyright protection. You can have unregistered design rights, so that protects how something looks. Nobody can copy exactly what you've designed, the way something looks. And you can also, in some situations, get unregistered trademark rights. Some IP rights actually need you to do something to put them into existence. So the most obvious there is patents. So that protects how something works. It protects something technical. And so you need to apply to get a patent. You need to apply for a patent application in order to get yourself a patent. You can also have registered designs. So that protects how something looks. So for instance, how a chair looks, you can protect that by a registered design. And registered trademarks. So that's just the branding or logo or the name of something, and it designates origin and has the reputation. To kind of highlight how IP can be protected, given the example of the iPhone, for instance. So this will be protected with lots of different IP protection. So obviously you've got trademarks. So iPhone is a registered trademark, which is kind of shown by the R there. The Apple logo, Apple, they'll all be registered trademarks. You'll also have registered and unregistered designs. So you can register how it looks, the shape of the iPhone. You can also register designs for how the graphical user interface looks as well. So how the apps are kind of displayed, that's all protected by registered and unregistered designs. You'll have a lot of patents. So that will be for things like the facial recognition, how the data is transmitted, how it charges, how the apps work, all things like that will be protected by patents. And you'll have copyright for the underlying code. So copyright can also protect kind of the actual code that underlies all the applications on the iPhone. And then finally, you'll most probably have a lot of trade secrets as well. They just don't tell anyone how it works. So that's how one product can actually be protected in a lot of different ways. So we'll now talk about patents in particular. So patents protect inventions. So that is something that's technical, a technical idea that's new and inventive. The earliest known patent, English patent, was in 1449. So they've been around for quite some time. But there's now around 6,000 patents granted each year in the UK, and many, many more worldwide as well. Patent protection is for 20 years from filing the patent application. So you have a monopoly right to stop anyone else doing what your patent protects for 20 years from filing. So you might ask, why would you want a patent? So what does the owner get? So the patent owner gets the right to stop other people from making or using the invention. So that includes selling it, using it, making it, importing it, exporting it, anything. You can't do that in the UK if you have a patent for that invention. But why would you want to stop people doing that? Well, it furthers the world's scientific knowledge, and it also encourages economic research. It's an economic incentive for research. So it's the concept that I've got an incentive. I can make money from my product if I invest in research. Basically, it's a reason to invest in research. So I wondered, have there been any, we could maybe pause for any questions at this point if we wanted to, if there's been any. I think someone might have raised their hand. Is there a...
Yeah, Hania, Shakil.
Hi, thank you. I actually just had a really quick question, which might come out as being vague, but I just still wanted to take my risk and ask it. So you know how you mentioned about automatic rights granted to companies? So I was wondering, why don't actually companies just go for having their rights being automatically saved, in the sense that so that they don't have to go through the hassle of these IP rights and all that, and have trade secrets already marked when they make a company or when it is established, let's say?
Yeah, so it's because you can only protect certain things. So for example, your example of trade secrets, you can only keep that a trade secret if it's not told to everyone. So for example, if you're selling a new hairdryer, you're selling it to someone can dismantle it and find out how it's made, and then they can reproduce it, and you can't then stop them doing that. Okay, so a trade secret is only secret if you keep it a secret. So for example, a recipe for something, you can keep that a secret because you can't, once Coca-Cola is made, you can't get the ingredients back out of it again. So that's an easy thing to be kept a secret.
Absolutely.
The same thing with copyright. So I work quite a lot in software and things like that. And although you get copyright protection for your kind of the underlying code of your software, it's only for the underlying code itself. So if someone's actually copied that code, you don't get any protection for the idea behind the code. So like what the actual code is doing. If someone makes a different code which does the same thing, then you don't get any protection. You can't stop them doing that. So the reason that people apply for patents is because you can stop. It's more kind of how something works, and so then you can stop them doing it regardless of whether they've copied it or come up with it on their own. So that's kind of why it's protecting different things, really.
Absolutely. If I may, can I ask a follow-up question? It's not a follow-up, but a new question, actually. So you know how you mentioned about filings. I was wondering, we do file for 20 years, but then is there like a passing time of how long it is taken to pass that? Let's say when I file for protection, how long does it take to get passed?
Yeah, so that's the problem sometimes, in that when it's 20 years from filing, and it can take a very long time to get a patent application granted. Sometimes you're arguing for 13, 14, 15 years, sometimes even longer. There have been cases, it's usually in the kind of pharmaceutical industry, where you're literally looking at about a year's worth of actual patent protection from grant. But for pharmaceuticals, obviously that's worth it sometimes. It can be very, very profitable. But I mean, you can get things granted within a year, but that's quite unusual. We're normally looking about 2 to 3 years from filing, and then you kind of get, what's that, about 17, 18 years of kind of patent protection, where you can then stop people from doing your invention, using your invention.
Right. That makes sense. Yeah. Thank you very much.
No problem. Okay, if there's any other questions at this point, then I can answer them. Otherwise, I'll move on. Okay. So now, what do patent attorneys actually do? So first of all, what is a patent attorney? So we are a member of the legal profession, but we're not solicitors, so we're not qualified lawyers, but we're qualified to advise clients about patents and also to help them get patents granted by the patent offices around the world. So you do not need to have a law degree to be a patent attorney. So in the UK, you can represent applicants at the European Patent Office, so that's the EPO. And the UK IPO, the UK Intellectual Property Office. And we also work with foreign offices and foreign attorneys even to get patents in other countries. So patents are kind of on a country by country basis. You can file for a patent in the UK, and then you've got to file separately if you want protection, for example, in the US or in China or in Japan or in Australia. You have to file with each patent office. Patent attorneys can either be employed in-house. So for example, Apple will have a patent department and they will work just on Apple products. Or you can work in private firms, private practice firms, which is what Mewburn Ellis is. So I work with lots of different clients on lots of different technical fields. I don't work for like a research company, for instance. So where does a patent attorney kind of fit in? So this is kind of the timeline of right from idea conception right through to expiry of your patent. And obviously the idea conception, that's by the inventor, that's not by us. But at one point, the inventor approaches the patent attorney and we need to understand the invention. So that's kind of the first thing that we need to do. We talk to an inventor and understand what they've invented. We draft, so we write their patent application for them. And we file it at the patent office. Why a patent attorney is needed at this point is because you need to be able to try and get the broadest protection possible. So for instance, someone may have come up with a prototype for something that's new, and a patent attorney will be able to realize, actually, we can get you greater protection than that. You've made it with a spring, but I can see that it can be made with elastic or something else, and you kind of broaden out the protection. So that's why a patent attorney is important for that. You then it gets reviewed by the patent office, and there's a bit of arguments back and forth about what should be granted, and then hopefully you get your patent application granted. So as I said previously, it's important to get patent attorneys involved because although in the UK, you can't in Europe really, but in the UK you can file and draft and file a patent application yourself as an inventor, but it's not really advisable at all. We've had to pass a lot of exams to be able to know all the law and the processes and the deadlines and how to do it. So patent attorneys are much more suitable for doing that. So in that a bit more detail then about what we kind of do. At the beginning of the process, as I said, the inventor describes the invention to the patent attorney. The patent attorney drafts the application to give the broadest protection. We agree on a final version and we file it at the patent office. And it's at that point that you've got patent pending. So you might have seen that on products before. It's more important in the US, but it can still be used in the UK as well. So that's kind of a warning to people. We are pursuing a patent for this product or for something in this product. And you can at that point put patent pending on your product. In the middle, the patent office searches for what is already known. So as I said at the very beginning, you can only get a patent for something that's new and inventive. And inventive means not obvious. And so what the patent office will do is we'll search for what is already known. That can be other patent applications, it can be publications in journals, things like that. And it will say, well, let's go on. It will say you'll get a search report and you'll get objections. So they might say that's not new, you can't have a patent for that in a kind of an examination report. As the role of a patent attorney is then to go kind of back and forth with the patent office and try and either argue that yes, it is not new and yes, it is clever and inventive, or you can sometimes amend the patent application to kind of narrow down the scope to get that patent protection. And then hopefully you get the patent granted. And at that point, you're patented, and at that point you can stop other people from copying or from doing what you're doing. I noticed there are a few in the chat few comments in the chat and another raised hand. So maybe we'll pause here quickly to answer a few more questions.
Yeah, one question from the chat is, why does it take so long for a patent to be approved?
So multiple reasons, really. The first is that the Patent Office receive a lot of patent applications and they have to all be searched and they will have to all be examined. I guess the second is that you get quite a long kind of time period to respond. That can be about 4 months to respond to an exam report. That obviously kind of slows things down as well. Though saying that, in recent years, it's got a lot quicker now. So in the UK and in Europe, after filing your patent application, they aim and they usually deliver the search report, so the first round of kind of arguments, within 6 months. So that's a lot quicker than it used to be. Apparently you used to find that you could be waiting years and years and years and not getting anything. There are ways to kind of accelerate it as well. So you can request acceleration, which means your application basically gets put to the top of the pile, but it's not always really needed. Sometimes you file an application and you kind of want to keep it on the down low for a little while you keep developing your product. You've not launched it yet or something like that. And so you don't really mind it being a bit slow. So it's kind of like a way to you weigh up whether you want it to get granted quickly or not.
Fab, and we have Hania Shakil again. Sorry.
Hi, yeah, sorry, it's me again. I actually have 2 questions. So my first question was, what are the chances of your argument? Let's say, you know how you said that the office might say, oh, it's actually not new, but then you can argue to the department and say, well, this is what the changes I've made. So are there like any cases or any, ratio that you have seen of how often these are agreed upon by the department? My first question. The second one, if I may, is that, you know how you mentioned about working for the European Patent Office? So I was thinking, has the Brexit and all that made a difference now?
Yeah.
A very easy question, I would say, but yeah, thank you.
Okay, so I'll go to the second question first because I'm just thinking about it. So no, the European Patent Office is completely separate from European Union. It's a completely separate organization, and so it has no impact. Brexit's had no impact whatsoever, which is great for me because otherwise I would have lost half my work. So that's good. But so that's the answer to the first one. The second one is, usually you can either argue or amend in order to overcome objections, usually. In kind of software, it's a little bit different. It can be really difficult to do that, but in a general sense, you can usually either amend your patent application a little bit. So that's kind of make changes to the claims, which is what is the kind of sentences at the end of the patent application, which actually defines the protection you're getting. Or you can argue against. I often find that the examiners have got it wrong, and you can kind of argue against, especially if they're saying it's not obvious, or they're saying it's obvious and you're saying it's not. There's often kind of wiggle room there to try and persuade them that actually no, you can get that is patentable. But yeah, so I would say usually you can get something granted. It might be very, very narrow because you've had to amend down to something quite specific in order to avoid all this other prior art, which is what's already known. But usually you can. Obviously sometimes you can't, and patent applications get rejected and you don't get a patent for them, but that's kind of the job of a patent attorney, really.
Absolutely, thank you very much, that definitely helps. Thank you.
Thanks.
Fab, we have one more question from Ritika regarding the European Patent Office. So is it required to know specific languages to read a patent if you're working for the European Patent Office?
Yeah, so the European Patent Office has 3 official languages, which are English, French, and German. And in order to kind of communicate with them, you have to speak one of those 3 languages, but it can be any one of those languages. And also to pass the exams, you have to sit it in one of those 3 languages as well. So yeah, English, French, or German.
Fab. Yeah, we're happy to take on more questions towards the end if you'd like to continue, or we have one more question as well.
We can do one more question now and then we'll do more at the end.
Do you need to hold a degree in field of science to be a patent attorney, from Rebecca?
Yeah, so I do get to this later on. You need to have a maths or a science degree to be a patent attorney. What I would say is what I did, I worked before in another firm, and there are a lot of IP lawyers there. And for that, you have to be a qualified lawyer rather than a qualified patent attorney. But that kind of is still in the field of IP, if it's something that you're really interested in and you don't have a science or maths degree, then IP lawyers kind of deal with everything to do with IP that's not, it's not about the writing the patent application, because it's kind of understandable, really. You have to be able to understand the science that a new inventor is telling you that their new invention about. And if you don't have a science degree, then you don't have the kind of technical background of being able to understand it, really, I think is the reasons for that. Okay, are there any other questions? I thought I saw a hand there, but maybe not.
No, I think that's it.
Okay, I will keep going then. So once the patent application has been granted and you've got a patent, is that the patent attorneys, is that the end of their job? No, it's not. So competitors, or what we call third parties, can attack a patent. So your client's just got a patent granted, hooray, and then it gets attacked. And it's the patent attorney's job to defend it. And it's also on the flip side, it can be our job to attack other people's patents as well. That's in Europe, that's known as opposition. So you actually, it's my favorite part of the job actually, is going to an opposition hearing. So usually they're kind of in Munich, but at the moment they're all by video conference. But usually you get to go to Munich and you actually, it's like a court hearing, you actually argue your case. That can then go to the Court of Appeal. And so patent attorneys can represent our clients in those hearings. At that point, hopefully the patent survives. It might be further limited, so further narrowed even more during opposition, but hopefully it survives in some form. At that point, you then have your 20 years from filing, so your patent term, when you can stop other people doing what your patent protects, but you must pay kind of yearly renewal fees. So they're, as I say here, they're between £70 and £600 a year in the UK. The reason for renewal fees is basically to prevent people getting patent protection. And then if they're not actually using their technology, they're not actually using their invention themselves, then it kind of opens up that everyone else can use it. It's like a deterrent for people doing that. So kind of the average day as a patent attorney. We read a lot, we think a lot, and we write a lot. So that's kind of what we do on a day-to-day basis, really. It's a lot of reading and a lot of writing, especially. But we also talk to inventors about inventions on the forefront of science. So by definition, their invention has to be new. And so that means that you are talking to, you and the inventor are the only people who know about it. And I think that's quite exciting. It's absolutely brand new science, and you're one of the only people that knows about it. So especially if you work in private practice, which is kind of like Mewburn Ellis, you work in lots of different areas of science. So not just in my field, it's physics, but it could be in chemistry, it could be in life sciences, biology, materials, and you see new inventions every day. So it can be completely random. One day I will be looking at, this morning it was blockchain, whereas yesterday it was a medical inhaler. So it can be completely different every day. And what's also quite interesting is working with clients on developing their commercial IP strategy. So deciding what inventions they want to patent and what maybe they shouldn't, or, oh yeah, let's file lots of patents in this country because you're doing that there, but maybe not so much in that country because it's not really needed. And that's quite interesting, and something I hadn't really thought about before joining the profession is it's not just technical, there is the kind of commercial side of it as well. Okay, so now on to kind of training as a patent attorney and what qualities patent attorneys need. So as I said, you need kind of good science or engineering or maths degree to be a patent attorney. You do also need an all-round interest in science and technology. You have to want to learn about new science, otherwise you won't be interested in the job. You need very good communication skills, especially in writing. So you need to be able to write the patent applications, but you also need kind of oral presentation skills as well. So if you're speaking at a hearing, you're kind of presenting your case, you need to be quite good at doing that. You need to be very organized and be able to work to strict deadlines. Sometimes you have a deadline that could be fatal to this patent application. If you don't meet this deadline, the patent application will die, or the client's money will be wasted. and the client's only given you instructions yesterday. So you need to be able to kind of work under pressure and be able to keep strict deadlines and handle several projects at the same time. It's good to have some commercial awareness, but I don't think it's necessarily necessary when applying. It's something that I personally think could probably be developed over time, but it's certainly something that could be seen as very useful in the profession. And then because a lot of firms are partnerships, it's certainly good if you have some skills that are interested in management, because kind of later on in your career, that's certainly something that would be possible. But yeah, the kind of key skill is all about describing an invention. So it's reducing an invention to its essential features, what actually makes it work like it does and why, and then writing a broad and clear definition. So kind of more about kind of training now. So the timeline of a trainee, this is at Mewburn Ellis, but a lot of firms are very similar. So the kind of quickest time that you could get dual qualified, so that's UK and European qualified, is 4 years. So for example, here, say you were starting September this year, you kind of work on real life cases, at least at Mewburn, for a year under like supervision of a partner, of course. But then you kind of, at Mewburn Ellis, we then go on a course at Queen Mary University in London, which is a full-time uni course, and it's a uni course in intellectual property, and you do that full-time, so you don't go into work at the same time. Other firms, you do need to go into work at the same time, but Mewburn Ellis at the moment, you don't. You then sit your UK qualifying exams for the first time 2 years after starting. And one thing that's very important, and actually a bit of a shock really, is that they are very hard. The UK qualifying exams in particular are difficult, and you're not expected to pass them first time. Many people don't, majority of people don't, and you just sit them the kind of year after. So it's kind of, you're not expected to pass at all. It's kind of if you can, that's great, but then you just take them again the year after. You then move on to European exams after the first sitting of the UK's. You take a pre-EQE, which is the pre-European qualifying exam. You can get your UK results after that. It takes ages for them to come out. It's like half a year. And then you do your European qualifying exams the following March. So that's 4 years really of kind of training, but all that time you're working on real life cases and gaining real life experience. So it's fine. So yeah, a bit more about the exams. As I said, the Queen Mary course is instead of the UK Foundation exams. So it's 3 months as a student, and it's full-time education. The UK qualifying exams, there's 4 exams. They are a law paper, so you have to know the law back to front. In the UK as well, it's closed book. So sorry, the sun's suddenly coming in. In the UK, it's closed book, so you have to learn it all off by heart. So it's kind of a memory test. There's a drafting paper, so you're given a situation where you're given an invention and you have to draft a patent application. Amendment, which is kind of that concept of responding to an exam report from the patent office. So the exam report says it's not new, and you've got to kind of write a response. And then there's infringement and validity, which is basically giving an opinion on whether someone is kind of doing what your patent protects. The pre-EQE, so that's the first European exam, is multiple choice. It's not easy, but it's certainly easier than the other exams. So that's kind of the first stage of that. And then you've got European qualifying exams, which basically mirror the UK exams. There is then a litigation certificate, which basically gives you right to speak in some courts in the UK. And that's just a 1-week course full-time that you do an exam on the Friday. So now I'll talk through some of the pros and cons that I personally think about the job. So this is just my opinion. Some of the pros, so I've spoken through some of these before already. So kind of the variety of work, both in terms of technology and the clients. So I work with loads of different clients. They can range from one person who came up with an invention in their shed and they want to protect it because they think it's quite clever, to university spin-outs, to big multinational corporations, to universities themselves, to US attorneys even, who they kind of give us work via their US clients. So it's loads of different types of people. It's very intellectually stimulating. It's very financially rewarding. So it's in the legal profession. So it is well paid, especially when you're qualified. And one thing that's good that is the main reason that I kind of joined the profession was that it enabled me to use my science still every single day without actually kind of going into further research. So I didn't want to kind of be stuck in one area of research and only learning about that. I wanted to like learn about lots of different areas of science, and so it enables you to do that. There's very good career progression, so you kind of know if you pass an exam, then you'll be a step up. You know, if you qualify, then you'll be the step up after that. And it is generally, at least at Mewburn Ellis, a very good work-life balance. I have friends who work kind of in other legal professions like solicitors and things. They work such long hours, whereas usually patent attorney is kind of a 9 to 5, 9 to 6 job, which is obviously good. So some of the cons, it is quite hard. There's stiff competition for jobs, so there are a lot of applicants per place. As I mentioned, the exams, they're hard and there's a lot of them, but you don't have too much pressure to pass them, which is good. It's just quite strange because if you've kind of got a good engineering or science degree or maths degree, you're kind of used to passing exams. It's quite strange to suddenly not pass them. But yeah, there's a lot of exams. And then the pressure to working to deadlines can sometimes be a con. It can be quite stressful, but on the whole, not really. Okay, some tips for applications. So because there's so many applicants for each role, apply to a lot of firms. It's very common to apply to lots. This kind of applies for any job application really, but a clear and personalized cover letter is very needed. You can't really just send out one application to all patent attorney firms. So put a lot of time and effort into the written parts of the application, and that's mainly because you cannot have any typos in the cover letter. Patent attorneys. So if you think about how something's described, a comma or the way something's phrased can completely change the meaning of it. It can completely change the protection you've got. So we're a bit obsessed with typos, and it could be like they could just put them off you if they see a typo. So that would be kind of a bit of advice, is just check for typos. Emphasize any science communication. Like I said before, it's quite an unusual part of the job, really, if for like the scientist to then be able to kind of write and kind of present well. So to kind of emphasize anything you've done that's to do with science about that, anything that's you explaining science or a technical area to someone else. I wouldn't worry about trying to learn anything about patent law, and there's enough time to do that on the job. I wouldn't try and talk and write like a patent attorney. I would just kind of stick to the technical side of things. And the interviews are very likely to be science heavy. I think one of my interviews at Mewburn Ellis was completely science questions. So how does that work? Why is that different to this? What makes it better than this? There weren't any other questions. Obviously, a second interview, there are a few, but I remember thinking like, wow, I'd learned all the what are your strengths and weaknesses, and it wasn't really needed. I wouldn't worry if you don't know the answer to a question at the interview. So how something works, that's kind of the point. They're looking at how you work out the answer. In fact, if you do know the answer and it's obvious you know the answer, then they'll move on pretty quickly. So yeah. And work experience is quite hard to get actually in a patent attorney firm. So if you can get it, that's fantastic, and that will really kind of look good, but I wouldn't worry if you can't. So now just a few slides about Mewburn Ellis itself. So it's quite a lot of information on this slide, but I'll kind of bring out some of the main bits. So we're growing very, very rapidly at the moment. There's been 40% growth in the last 3 years. So since I joined the firm, it's like just grown hugely. 70 people in the last 3 years, and a lot of that's been in the patent team. So we've got 5 offices altogether. 4 of them are in the UK. So they're in London, Bristol, Manchester, and Cambridge. And we've got an office in Munich as well. That's where the European Patent Office is based. So it's quite an important office there. Another important thing, what I think at least, is that 50% of our technical trainees, so that's our kind of new trainees, are women, which is a lot higher than the average in STEM. And kind of we're rated very well in the kind of the legal rankings, so top tier, recommended, gold ranked in certain rankings. So that's kind of also important. Kind of another slide with quite a lot of information on, but it's kind of a brief history. So as I said previously, we're one of the oldest firms in the UK. So kind of it was established in 1867. And what's interesting is that Mr. Mewburn was actually kind of a pioneer at CIPA, which is the Chartered Institute of Patent Attorneys. So kind of the person who founded the firm actually was heavily involved in kind of coordinating the kind of the UK Patent Attorney Association. Another point that was interesting is that Mewburn Ellis had the first ever female patent agent, they were called then. So that was in 1936. We then kind of, the firm has grown over time, new offices and things. We now have a solicitor team. So I mentioned before that although you need a science degree to be a patent attorney, you can be an IP lawyer, and we have a solicitor team at Mewburn Ellis, who they're IP solicitors. So they deal with a lot of things, such as they deal with more the side of things like after grant. If someone is infringing your patent, we'll get the IP solicitors involved, and we'll be able to kind of work with them. We'll provide the opinion of, yeah, they are copying, they are infringing the patent or the patent, and the IP solicitors will sort more the kind of the terms of what they're going to do to stop the other person doing that. So that it is a really important and very exciting role. In 2009, the office went completely paperless, and in 2017, that was when our Munich office opened. So we kind of landed in Munich for further expansion. So a bit about career progression at Mewburn Ellis. So you're kind of a technical assistant or a trainee at the beginning. When you qualify, you become an associate. So that's what I am at the moment. About 3-4 years later, you become a senior associate. So as I said previously, it's all very structured career progression. It's quite nice to know where you're heading. You know that if you qualify, you'll become an associate. If 3 or 4 years later, you'll be a senior associate. And if you meet then certain targets, you can either be an IP director or a partner of the firm. They're kind of similar roles in that you're similarly experienced. You have your own patent portfolios that you run for your clients. It's similarly paid. But there are a few differences in that a partner at Mewburn Ellis does training, so they have their trainees. They're kind of more involved in business development, so trying to win new work and things like that. They have a share in the profits of the firm, whereas IP directors don't. But IP directors have they have more flexibility in working. They're allowed to work from home full time. Obviously, at the moment, everyone's working from home usually, but in normal times, IP directors can do that. And then a junior partner can become a full member as well. So that's kind of like a senior partner. So that's kind of the career progression through Mewburn Ellis. So something that's quite unusual about Mewburn Ellis is that we do rotations. So basically, during our training, before we qualify, we have to rotate around the offices a little bit. So they can be in any of the 5 offices. And the reason we do this is it's really good to work with different people on different types of work, different types of cases, different types of client, different technical fields. And it's really good to be able to work with different partners around the firm. Personally, it's been fantastic for me. I still get work from all of the partners that I've worked with, rather than just be sat with one person. If you sit with one person and you don't like their style of working, you're kind of stuck. Whereas if you move around, you can kind of get the best bits from the different people, like best bits from how everyone works, and then kind of become a better attorney at the end of it, basically. It's also, I mean, they're all really nice places as well. So they're all really good cities. So it's very fun. We normally do about 2 to 3 office rotations. I actually did 4. So I went to all the UK offices, but usually it's around 2 to 3. And yeah, they're about 6 months in each office usually. Okay, so some of the benefits of training at Mewburn Ellis is, so obviously, as I just said, training with different people. I think at some other firms, you are stuck with one partner throughout your whole training and you only learn from them. That can be difficult if, for many reasons, you might just not get on, but also you might just not like their style of working. You might think there might be a better way for you to work, and you don't know that if you're only sat with one person. We have we're known for our in-house tutorials, so our training basically. So during training, they're once a month, and all the trainees in your year will come together, usually at one office. It's obviously difficult at the moment with COVID, but usually you'll kind of all go to one office, and you will kind of do practical questions, practice the law, and things like that. So it's trained by the partners at the firm. So the partners provide the training, and it's just very good to do that on a monthly basis. We also continuously learn kind of throughout. We have a lot of training, even when qualified, monthly. So you're continuously learning. One thing that's I really liked is that your kind of value is noticed and used from the very beginning. So I remember it was my maybe first week or something, and I had no idea what I was doing, but the partner who I was working for basically said, you have just finished your physics degree, you know the most about physics than probably anyone else in this room at this point, because you've just finished, you've got all that information in your head, can you help me understand this pattern? And I was like, that's really nice. I'm kind of, my skills are used a lot at the beginning, and then kind of as you go through, kind of your skills are still used. And I thought that it was nice that you're valued from the very beginning. Again, it's immediate and direct client contact for all trainees from day one. You're working on live cases. You often can communicate with the clients. So yourselves, you're in meetings from the very beginning. And that's really important for training. You need to kind of see how everything works from the very beginning. And as I said, because you've got this continuous learning all the way through, we often have kind of lunchtime sessions. One of the other kind of perks is we have an annual two-day IP boot camp, it's called, and it's basically where everyone in the firm, so that's from all the offices, comes together, usually at kind of like a hotel complex. And in the day we kind of have seminars and discussions, but in the evening it's just really nice to get to see everyone. So that's kind of a good thing that the firm put on for us. We have nice dinners and drinks and entertainment, so that's really good. There's also some opportunities for travel as well, which is another great thing. So as I said before, kind of the hearings, which is the oral proceedings, they're usually in Munich or The Hague. But we also go on quite a few client visits, usually, obviously not at the moment, but so especially to the US and Japan, I would say, kind of main places where you go on client visits. And in normal times, you would do that kind of once or twice a year as a qualified attorney. They also offer secondments. So that's post-qualification, you get the opportunity to kind of go and live in the US, Japan, Korea, Australia, kind of wherever you choose. And it's basically you either work at, say, for example, a US patent firm, or you might work at your US clients, just kind of help them with their portfolio. But that's something else we kind of offer as well, in that you can, for usually between 6 months and a year, you can kind of go on secondment somewhere else. It's basically to build the client base and kind of provide a stronger client base. We also have relatively flexible working hours. It's difficult at the moment with everyone working from home. Everyone can kind of work when they want, but usually we kind of have core hours, which are between 10 and 12 and 2 and 4. And other than that, you can kind of fit in your work around those hours. You don't need to be in the office around those hours. You just need to be in those core hours. And apparently a Mewburn trained attorney is an excellent attorney. Okay, so I think this is my last slide. So this is just a bit about kind of our programs that we've got under Forward Community Program. So first of all, diversity and inclusion is very important. It's kind of on the forefront of Mewburn at the moment. So we've recently all had D&I training. There's been lots of initiatives about it. It's obviously very important. We have a very strong mental health committee, which I'm involved in, and yeah, you need to. That's obviously very good. We also do a lot of other things, so things like sponsorship of Crest Awards and mentoring of children. So kind of giving back in that sense as well. Sustainability, obviously, kind of we've been paper-free, not carbon-free, paper-free for a long time now, but it's kind of focusing on going back to normal life after COVID. How do we need to travel all the time? We've been doing video conferences for our oral proceedings. Maybe we shouldn't always travel. So it's kind of things like that are always at the forefront. And then finally, community initiatives. Every year we give 1% of our profits to charity, and it's a charity that's chosen by the employees of Mewburn Ellis. So kind of we vote on what charity wants to give it to. And kind of some of our partnerships are listed there. Okay, so I think that's kind of the end of the presentation. So now we can kind of go to some more questions if anyone has any.
Yes, we actually have a few questions from on the chat box. So first question, on what basis does the attacking and defending takes place?
On what basis? So is that kind of the during after grant, when you're kind of attacking or defending someone's patent, right? So you can kind of say that patent shouldn't have been granted because it's not new or it's not inventive. The Patent Office haven't done their job properly, and therefore it should be revoked. It should be kind of taken back. It shouldn't have been granted in the first place. So you can attack it kind of on that basis, that the Patent Office haven't done their job properly. And then again, you kind of defend it saying, no, it is new. It's new for these reasons. That this part wasn't known before, therefore it is new. So it's on the same kind of arguments that you make to the Patent Office, you're then making to kind of a competitor.
A second question, would the QM course count as a postgraduate degree, and how much do you have to pay for the fees?
So I think it's an PG cert it was. So yeah, it's a postgraduate kind of course. I'm not sure it's a full degree, but it's a postgraduate course. And usually your firm pays for it. So Mewburn Ellis certainly pay the fees for that. So, and I would say majority of, if not all of the people I spoke to were kind of employed at a firm who paid for it. They weren't doing it just themselves before getting a job.
And the third question, I guess you talked about it, like law graduates can qualify for a patent attorney only if they become a lawyer.
Yeah, so you can't qualify as a patent attorney if you don't have a science degree. There's no way of doing so. It's a prerequisite that you must have a science or engineering or maths degree. But you can do an alternative role, which is an IP lawyer or IP solicitor. So you're still very involved in IP, and in some ways it might be the more exciting parts of it, in that you're kind of your client comes to you and they say, someone's copied me, what can I do? That would be the kind of IP solicitor that would be helping with that. There'd be stopping other people, there'd be kind of the communications, the back and forth. They'd even be going to court if it became infringement proceedings. So it's that kind of role. They just wouldn't be involved in the actual talks with the inventors, actually drafting it, because you need a science degree to be able to understand the science that the inventors are telling you about, basically. So it's a separate role. But at Mewburn Ellis, we have a legal team, so we have IP lawyers working here. And we kind of work together on a lot of things, but it's just a slightly different role.
Okay. How is international representation in Mewburn Ellis?
International representation, yeah. So it's very good. I must admit, it's very good in the with trainees. In the partnership, it's very good in that the kind of male to female ratio in the partnership is good, about 50-50 actually. But in terms of kind of like, yeah, international representation, it's in the trainees, it's good. And obviously over time, they'll develop into partners, and then it will become much better. But it's certainly something that's very important, and it's something that Mewburn Ellis are really listening to at the moment. Kind of, we've had a lot of diversity and inclusion training, so it is very important.
Okay, and one last question. I was wondering, when during your degree did you decide you wanted to become a patent attorney, and why?
Okay, so when did I decide I wanted to be a patent attorney? I remember it was quite strange actually that my dad introduced me to the profession. And the reason being is because I didn't know whether to do physics or kind of law at university. And so I remember at that point he told me about it. In the end, I decided to do physics and kind of forgot all about it. And then I had applied to do PhDs, and I'd even accepted a PhD offer. And it was at that point that I kind of realized, oh, I don't know if I can last 3 or 4 years kind of doing just what I've signed up for. And it's at that point that I kind of remembered, oh, there's this other profession, and I looked into it at that point and realized that it was kind of definitely the role for me, mainly because I'm quite good at writing, so you need to be good at writing, and I thought that linked my good skills in writing to my good skills in science together, and I still got to see a lot of science, which was really important to me, but I wasn't stuck in a lab, basically. So that's why I decided to be a patent attorney.
And we have now two questions that are related, and we have Hania who has her hand raised. Do you need to have a PhD, and would you class a BS as a good degree? And do most trainees start straight after an undergraduate degree, or do many people have a postgraduate degree or have worked in industry?
So you definitely don't need to have a PhD. I would say about half and half of new trainees have PhDs to having an undergraduate degree. And I mean, there are some reasons that a PhD would be good, in that you probably have a bit more experience on kind of written communications. You've written a thesis, things like that. But realistically, it's quite unusual for an inventor to come to you with something very specific that you've looked at in your PhD. So you might know a lot about that specific thing, but that would be quite unusual. Usually a BSc or MSc is is absolutely fine. So yeah, I've got a master's degree, but it was kind of an integrated master's, so it was like one undergraduate degree, and that's fine. A lot of people have that. In terms of kind of working in industry, no, most people come straight from university. Some people have done PhDs, have worked in industry and research, and then become a patent attorney. But I would say most people are kind of straight from uni, either as undergraduate or after a PhD.
Okay, so now we have Hania who has her hand raised.
Hi, sorry, it's me again.
Okay.
I just have a question in regards to where I'm coming from. So I am basically a second-year law graduate, so that's why I'm interested in IP, I would say. So I was wondering, is the progression process and the other stages similar to how you mentioned about the patent attorney in Mewburn Ellis, in terms of saying, would I be, if for example I apply, would it be possible for Mewburn Ellis to sponsor me for my LPC or SQE, let's say, or is it different?
So I don't know as much about kind of that process, but it's certainly something that you could ask them. And kind of the career progression is similar in that you can become a partner of the firm, being an IP solicitor, and you can become an associate. So you're a trainee, associate, and then a partner. So that kind of career progression is the same. And I would think that, I don't know the answer. You would kind of have to apply and see if they would kind of pay for your funding, but because they pay for patent attorney kind of exams and training, I don't see why not, but I can't really answer the question because I don't know.
Absolutely. Just a follow-up question. I'm not sure if this would be a question for you, but just out of curiosity, how early on applications do they take for IP solicitors in the firm?
I'm not sure, to be honest with you, and I'm not even sure that they are they're advertising for roles. One thing I would say is that it can never hurt to apply and never hurt to write to someone and just ask. So kind of, even if they're not actively advertising for a role, the legal kind of team is growing quite rapidly, and it could be something that a very good applicant they would consider, even if they're not actively advertising. So so you say you're a second year. I think so. Mine was a 4-year course, and I think I did apply in my final year. So maybe yeah, in your final year, something that you could apply for.
That's really good sign. Just a follow-up question, the last one I would say. How many would you say do we currently have IP solicitors in Mewburn Ellis?
How many? We have so I think there's been a lot of new solicitors. I think there's probably it's a smaller team than the patents. The patents is by far the biggest, but probably around between 6 and 8, I think, trying to count. So they're the smallest team, but they are growing. I mean, it was one person for a while. So it's kind of it's growing. It's something that we want to become more involved in. It's kind of the litigation side of things. So kind of after a patent grants.
Absolutely, very interesting.
Yeah.
Thank you very much. I really appreciate your time. Thank you.
Thank you.
I think those are the most of the questions. I think the last one again related to whether Mewburn Ellis has IP lawyers, which I think you have touched upon last one. Yeah, that's most of the questions from us, and yeah, I would like to wrap it up. Thank you so much, Lucy, for your time. And if anyone wants to connect, just get in touch, and we'll forward Lucy's LinkedIn or email.
That's
And
fine.
we'll also upload this video by the end of this week. So I know someone had asked about the slides, so you can definitely go to the videos again and the presentations Lucy gave. Thank you so much, Lucy.
Thank you very much for having me.
Have a great week.
Thank you.
Take care, everyone.
You too. Bye.
Thank you. Bye.